Good afternoon. I'm excited to welcome you all to our presentation today, Willowbrook and the Road to Inclusion, Rethinking Guardianship for People with Intellectual and Developmental Disabilities. It's been 50 years since the expose of the Willowbrook State School aired. For the first time, the public saw the horrific abuse and neglect that was happening behind closed doors. And throughout this year, Disability Rights New York will be bringing awareness to the events that led to the closing of Willowbrook, the historic changes that took place in the way services were being delivered to people with disabilities, and the work that still needs to be done. We have a distinguished panelists who come to you both with extensive professional experience, but also personal experience in the field of guardianship. We're going to begin today with Rosemary Bailey. Rosemary is special counsel to the Government Law Center at Albany Law School. She has also a great deal of professional experience in guardianship. And so we asked her to come and start us off today by explaining what guardianship is and what forms it takes currently in New York State. So Rosemary, if you'd like to begin.
Thanks, Jennifer. So the law says that all adult persons are presumed to possess legal capacity unless and until a guardian is appointed for them. So what is a guardianship? Guardianship is a process by which a court appoints a decision maker for an individual found by that court to be unable to make decisions for their own personal care and financial matters, usually because of an underlying mental disability that impairs their ability to do so. The guardian is the person who's appointed by the court, often called a surrogate decision maker. But in reality, the court is the guardian. The individual who's appointed by the court is the court's agent. And that person has what's called a fiduciary relationship with the individual for whom the guardian is appointed. So the guardianship is the process, and it's also the relationship that the individual who has a guardian enjoys with the person who's the guardian. How does this all come about? Well, the appointment of a guardianship is really rooted in what's called the Doctrine of Patriarch, which is the primary justification by which a court can remove the rights of one individual and lodge them in the guardian. States have a compelling interest in caring for their citizens who are unable to care for themselves because of some mental inability. And for the state to invoke this power, the person has to be found to lack capacity. Otherwise, they shouldn't be able to do it. With the exercise of this parens patriae power is the requirement of due process, that in order for the court to appoint a guardian, there should be a hearing, a determination based on clear and convincing evidence that the person lacks capacity to make decisions for themselves, and that the guardian should be given only the powers necessary to make decisions for the person, that the powers are tailored to what the person needs. And it's also been said that the court should require due process and not, and rather require that there be annual or some type of periodic review of the guardianship to be sure that the guardian is doing what the guardian is supposed to be doing, and also to determine whether the person no longer needs the guardian. We have two guardianship statutes in New York, and we're going to be talking more about them as the program advances. But to begin with, we can say that there's a guardianship, a general guardianship under Article 81 of the Mental Hygiene Law, and a specific guardianship for individuals with developmental disabilities, Article 17A of the Surrogate Court Procedure Act. The general guardianship, Article 81, provides for the appointment of a guardian for any adult whose decision-making capacity is impaired and determined by the court to be unable to appreciate the consequences of that impairment and possibly the harm that could befall them. The focus of the guardianship is on the person's abilities and limitations rather than on their underlying diagnosis. which means that a guardian can be appointed for a person with a developmental disability under the general guardianship law. As it turns out, most guardianships for people with developmental disabilities come through the Article 17A guardianship, which is really the focus of this presentation. Under the general guardianship, there's a hearing, there's a right to counsel, clear and convincing evidence must be put forward that the person lacks capacity, and the authority of the guardian is limited to what the individual needs. And finally, there's an annual review. The developmental disability guardianship, Article 17A, is limited to individuals who have been diagnosed in childhood with a developmental disability and a category of people who have traumatic brain injury, but I don't believe we're going to be focusing on them today. As Beth will talk more about, the guardianship for developmental disabilities cases is an addendum to guardianship for minors. And it's really grounded in the idea that individuals with developmental disabilities were perceived at the time it was enacted as people who would be childlike forever. And hence the role of the guardian was more like that of a parent. It's typically a plenary guardianship, meaning the guardian's authority is not tailored to the needs of the individual, but all-encompassing. And the hearing that is called for in Article 81 can be dispensed with if the petitioners for the guardianship are the individual's parents or are seeking the guardianship with the parent's consent. One of the significant things that people often bring up is the difference in cost. A guardianship, a general guardianship, is more expensive, not only because of the filing fees, but also because of filing fees in the court, rather, but also because of the involvement of lawyers. Article 17A has a more of a do-it-yourself feel to it. In any event, the guardianship, whether it's an Article 81 or a 17A, directly impinges on a person's liberty, interest. And despite the seemingly benevolent nature, when we talked about the state wanting to care for its citizens, the consequences of guardianship can be very harsh. When the court appoints a guardian, the individual loses their rights to make decisions. Historically, guardianship was the preeminent way to address the needs of an impaired individual. But today, as Kim will talk about later, we have other forms of decision-making, surrogate decision-making, which have rendered guardianship in the position of last resort. And in fact, most courts look upon guardianship as a remedy of last resort. Although, as we'll see with Article 17A, that really doesn't capture what happens in Article 17A. So I think that really puts us in that place to begin, Jennifer, talking about what guardianship can do for parents.
Thank you, Rosemary. I'm going to move now to another of our panelists, Carrie Birkin, who is going to provide a family member perspective of guardianship. Carrie, do you want to start us off by introducing yourself? And I'm happy to jump in with some questions if after you do that.
Thanks. So I'm Carrie Birkin. Professionally, I work for Strong Center for Developmental Disabilities, which is part of the University of Rochester Medical Center. I wear a lot of different hats there, but all of those hats have something to do with families, and that's because I am a family. And so that's why I'm here today. I am a mom to two fantastic daughters. One is 17 and one is 19. And my 19-year-old Ella has Down syndrome. And so I think that from parent perspective, I'm just going to sort of tell you a little bit about the guardianship journey that I've been on so far, which is short, but it has all the components that I'm experiencing, that Ella's experiencing, and that also I know a lot of other families in our community are experiencing. So when I first started to think about guardianship, a colleague of mine was going through the supported decision-making process to become somebody that shepherds people through the process. I don't even know what the title is for that role.
Facilitator probably what.
Thank you. All right, facilitator. It's probably better than the shepherd. So she was working on becoming a facilitator, and she's very excited, and it sounded great. And Ella was probably 14 or 15 at the time. So I'm like, fantastic, we have a solution. I will just let this process work itself for the next 4 or 5 years. And then when Ella turns 18, I will jump on this bandwagon and we will have a solution for Ella to have say in her future, but also for me to guide her. Now, this is nothing against supported decision-making. It's just currently not where I wished it was, or where we need it to be so much. And I think it's not necessarily the process, but it's more how available it is to families and how much we understand about it. So Ella then turned 18 at last year, and it's on a lot of people in her professionally in her life's checklist guardianship. So I heard from her service coordinator or care coordinator. I heard from a few of her specialists and her pediatrician about getting guardianship, and it's on the checklist, and this is what we need to do. And I thought, okay, well, while supported decision-making is cooking and doing its thing, let me check out traditional guardianship. So I went to an agency in our community, that supports families in doing this. And I talked to them and they were wonderful. But the piece that really stood out to me was the fact that it was sort of blanket guardianship. So it was not really catered to Ella. It wasn't really Ella centered. It was just, here are all of the things. This is how it works. This is what you do. This is what you say, and this is what you get. And it was affordable. It was like $350, I think. So self-direction would cover a big portion of it. So I thought, well, maybe we should do this. But then I thought, okay, currently, I think that Ella and I have good communication to help her make the best decisions, but we know I'm not always going to be around. So then that transfers the power to somebody else, that I have to be very, very sure that they have Ella's best interest in the center. And how can I be sure of that? I never can be sure. So I didn't love that idea. So then someone said, okay, check Article 81. Okay. Talk to an attorney that does Article 81. Again, he was lovely. He gave me a wealth of information, probably spent way more time with me than he had planned on. But at the end, I learned that it's about $5,000 just for the basics, no frills. And although it's a lot of work and he deserves the $5,000, I don't have a stack of cash to be able to just give over. And I know a lot of other families don't either. So I thought, all right, we'll push pause on 81, but still, even with 81, there's a lot of power that is held. And so brings us to current day, where I'm happy we're having this conversation. I think a lot more conversations like this need to happen about how can we how can we make this person-centered? And, you know, when I think about it, I think about the words that we always, since early intervention days with Ella, you know, self-advocacy, self-determination, and independence. And I think about independence, and that word is on probably every document that's ever been written for Ella, her IEP, her life plan, independent, independent, independent. And I just find it so ironic that we get to an age of traditional independence, but we're saying, but I'm going to hold all the power, right? That's going to be me. And so I really think, now I'm an optimist, I'll fully admit that, but I really do think that we have the power to figure this out. We have so many smart people in our community. I think we have the power to figure this out, but I think that we really need to work on it. I think this is a great first step, and then I'm excited to see where this conversation goes.
Carrie, I think you gave a great foundation of where we are in terms of, you know, the experiences, and I know others share that experience that you're going through, that there must be something different that we can do. I'd like to turn it to Beth Rulis, who is the attorney with the American Civil Liberties Union of New York, but also class counsel in Willowbrook. And I thought, Beth, you could kind of bring us this historical perspective of how we arrived here, walking us through the enactment of 17A in 1969, its connection to Willowbrook, and how we arrived at where we are in this place in time.
Sure. I'm really happy that you're all doing this. I mean, it's ironic, right, that 17A was enacted in 1969. The Willowbrook case was filed in 1972. You have two sort of systems of law that manifest in that dichotomy. In 1969, the legislature enacted 17A. We need to understand that 17A was an outgrowth of Chapter 17 of the Surrogate Court Practice Act, which dealt with guardianships and custodians over young people, people under the age of 18. So 17A was considered to be sort of an extension of a traditional concept of guardianship over young people, children by their parents generally, because it rested, as we know, on a very sort of paternalistic concept of people with developmental disabilities. 17A applies to people with DD who reach the age of maturity as a legal matter. They come to the age of 18. And we have what has developed over the years, almost a school to guardianship pipeline, where the theory is that people with DD never grow up. They are continuously infantilized. It rests on the constitutional principle that a parent has the right to direct the custody, care, and control of their child. And when you build society's perception of a person with developmental disabilities into that construct of child, it became completely natural in the system of the time to extend that legal fiction to the adult person with DD. It was not ill-intentioned. Then, as is now, society forces people in a parental relationship to demonstrate that they have continuing legal control over their child, who may be an adult, but because of disability is perceived not to be able to live independently, make decisions, provide medical consent, open bank accounts, and function in day-to-day society. Parents and advocates at the time did not want to go through what was the sort of conservatorship protocol that was in place. You heard Carrie talking about the Article 81, which is sort of arose from the conservatorship issue. It was very complicated. It was a very full-blown procedure. There were ongoing reports to the court, which, from a due process perspective, obviously as a constitutional person, we appreciate. But parents really wanted this sort of do-it-yourself approach that was inexpensive, that was sort of a one-stop shop with the court. The New York State court system, OCA, has standard forms. Court personnel assist families in filling out those forms. It was intended to be something that was not supposed to burden a family, but just continue their control over their child, even though the child was 18. It gave the parent the right to participate in medical appointments, to provide medical consent, to address resources and assets. As we moved into Social Security and Social Security disability, and ultimately Medicaid, families would not have the right to actually control and direct the way monies are spent on behalf of their children. If their children inherited money from a grandparent, same thing. They didn't have the piece of paper, then they had no right to control that resource. Again, you just are seated in sort of the 60s and the 70s. But as we moved forward, as we had the deinstitutionalization movement, as the doors to Willowbrook were thrown open and people were actually restored to the community, to the world, we had a different understanding develop about people's potentials, about people's ability to articulate, their choices. And we moved away from this medical model, but it's in the confined sphere of the community who work with people who have family members with developmental disabilities. Because society really hasn't caught up to that. Society is still lodged in a very ableist, very pejorative, stigmatizing state of affairs. So while the field moved forward, all of us, advocates, parents, the people themselves, the self-advocates, are human beings, have human rights, have legal rights, have the right to articulate choice. So what do we get in New York State? They expanded the definition of 17A to include not just mental retardation, because the R word was still being used then, but they expanded it to include people with developmental disabilities. Didn't change the construct, just added more people, because DD became a diagnosis that was applied to people with developmental disabilities. So again, you have the perception that anyone with a developmental disability is a child, ongoing acknowledgement that the parent has a role. This role is granted in perpetuity to control and direct the upbringing of their child, because their child is a perpetual child. The emphasis really has always been on empowerment. And remember, the Willowbrook case was about protection from harm. We expanded that over the course of the years, and my predecessors and I have all worked towards, a sort of institutional perspective to protect people from harm, to permitting in the least restrictive setting the person to have the most access to a normalized existence, which includes control and direction lodged with them. We are moving in a sort of fashion towards the empowerment of the individual. But again, as I said, society has not caught up with that. So you have so many restrictive protocols out there. You cannot walk into a hospital if you have an 18+ child and have access to medical information. You can't advocate for your person if you don't have a piece of paper that this hospital recognizes. And the hospital's recognition is not necessarily in guise of protecting the person. It's actually in guise of protecting themselves. It's a liability issue. If the hospital doesn't have a name and a signature for consent, they can be sued. They don't see the person, they see their institutional liability. Same thing with the bank, they don't want, a credit card taken out. They don't want loans being made. Landlords, we can't sue a person with a developmental disability, because in New York State, if a person has a disability, your contract can be voided by them, but you as the landlord can't void that contract. So landlords won't engage in business transactions with people with developmental disabilities. By the time we get to 1990, the legislature directed a reevaluation of 17A. And specifically, they spoke about the changes in the quote, care, treatment, and understanding of these individuals, as well as new legal theories regarding the rights of such individuals. Again, ableism coming from our elected officials. They were supposed to have had this report provided to them by the end of 1991. What they did in 1991, the New York State Law Revision Commission decided that Article 81 should actually be enacted, because that would be a better, more protective guardianship regime. And they left 17A in place. So 17A is pretty much unchanged. What we do have in 17A is also the ability for people in a parental relationship to a person with DD, the right to make end-of-life decisions with respect to withdrawing or withholding life-sustaining treatment. You don't need a guardianship order, you just need to show your relationship. There are some concerns there, obviously, but again, because the Family Healthcare Decisions Act for all the other New Yorkers was tied up in disputes and wrangling, we ended up with another off-ramp for people with DD in 17A. We are currently in a state of legal affairs where 17A is supposed to be reconsidered for abandonment or merger into the Family Healthcare Decisions Act, at least as it relates to medical care and treatment, because the theory is it's a separate and inherently unequal system that addresses the rights of people with DD at the end of their lives versus the general population. I mean, I can argue it both ways. I think there are safeguards in 17A, 1750B, which is the provision. But again, the motivations are coming from a very paternalistic concept in the state legislatures. The National Developmental Disabilities Act that was enacted in 1963, which was sort of the precursor to our 17A, was really updated and changed in 2000. And you had involvement from self-advocates, families, other advocacy groups, the lawyer people and the like, really pushing for the national perspective of people with disabilities to be expanded to recognize their personhood. There's a lot of talk, there's not a lot of action. And so we are where we are today, where we still have a very sort of society imposed on families and people legal constraints in order to effectuate that person's presence in day-to-day activities in life. So I think
that's a good foundation. Yeah,
okay,
thank
good.
you for bringing us up to date. Let me turn back to you, Rosemary, to examine, one of the questions that we're being presented here is, today with that kind of foundation is, does 17A still make sense in 2022? And, what is the price that what are the benefits and then the price to a quick or easier guardianship on families and also people who are then subjected to that guardianship?
Thanks, Jennifer. So I'm going to just go back a little bit to what Carrie said when you brought up talking about Article 17A compared with Article 81, which sort of, I'm glad you did, because we're talking about the two forms of guardianship. I have to confess a little protectiveness towards Article 81 because I was actually involved as an attorney with the Law Revision Commission when we did propose to the legislature, and they adopted the changes to the prior formats that wound up being Article 81. And so a couple of things that I think will help bring us to where we're intending to go today. As Beth pointed out, Article 17A was left in place at that time. The tension that exists now about whether Article 81 should be the premier guardianship statute in New York or 17A should remain is as fresh in my mind today as it was then. On some level, the more things change, the more they remain the same. That's where we are today. And I have a list of things that have happened, and I'm happy to go through them, but maybe we can just talk for a few minutes first. Even within Article 81, before even considering what 17A should have or should not have been included, or there should have been distinction made. Remember, Article 81 applies to everyone. There is no distinction. You don't have to present a particular diagnosis to have that statute applicable. And yes, it is costly, and there's no way around it because the provisions encourage steps that are taken that involve more detail and more analysis than 17A asks for. But there, even with in Article 81, there's a tension between, on the petitioner's side, wanting something that will allow them to protect the person under the guardianship and happen as quickly as possible and give them as much authority as they could possibly anticipate they will need, versus what about the person who's the subject of the guardianship, their rights are being taken away. How should they be taken away? What process should be gone through before those powers are taken away? So even within that one statute, there's that tension about what happens. And then we have 17A that reflects one particular view of how that should work. It's interesting to hear Beth talk about, the steps that have gone along in terms of where we have gotten today, even though we still have the Article 17A statute. I have a list in front of me and I won't go through it, but really beginning in, as Beth alluded to, in the 1960s, there were committees and commissions who were suggesting that a person who had a developmental disability should also receive the due process protections that are accorded generally, that there should be a recognition of differing abilities and that a statute should reflect that, that there should be a periodic review of guardianships. And even coming up to the present day, the UN Convention on the Rights of Disabilities has said this is a struggle that's across the world of recognizing the person's capacity, and that it's a human right and it should be enjoyed on the basis with all other aspects of life. And even, as we know, the mental hygiene law talks about inclusion and independence and self-determination, and OPWDD's policies on its website talks about those same things. And every piece of literature that anybody could read will articulate all the things that Article 81 provides in its law regarding the rights of the individual to have counsel, the level of evidence that should be present, and the requirements for periodic review and a clear path to terminating the guardianship. All of that. And believe me, I think between Jennifer, Beth, myself, other people who are on the call, we've all lived through this. At the same time, starting in 1990, as Beth indicated, the legislature in New York called for some type of reform of Article 17A. The draft report that she mentioned actually fell into my hands through a student doing a FOIL request. And you have to laugh because it's labeled draft, and anyone who's familiar with FOIL requests in New York, where you can ask an agency for something, they don't have to give it to you if it's a draft. But it fell into my students' hands, and lo and behold, the report says Article 17A should be reformed so that it's like Article 81. And I can go on because we have now in 2013, the Olmsted Cabinet issued a report, and what did they say? The same thing. There have been legislative proposals to amend Article 17A to mirror Article 81. They've gone nowhere. The courts themselves, a number of surrogates have said we should, we have to actually apply provisions from Article 81 in 17A to have the statute be constitutional as they apply to this individual. DRNY had litigated the issue. The case was dismissed on procedural grounds, so the substance was never issued. In fact, today in the Appellate Division's Second Department, DRNY's counsel is arguing about the constitutionality of the statute, in particular, the burden of proof on an individual who's under a guardianship, who wants to get rid of the guardianship. And that case is a very compelling case for a young man who, I mean, just it's apparent that the court was just not realizing that when someone makes a bad purchase of an automobile and they adjust their budget, that if that isn't evidence that a person doesn't need a guardian, it's hard to understand what might be evidence that they don't need a guardian. Even like within the last year, the surrogates court judges themselves acknowledged that maybe the statute should be amended. And the Disability Rights Committee of the State Bar has come out with a report saying the statute as it stands is unconstitutional. Where does that leave us in terms of what to do about 17A? My personal view is that Article 81 should be amended to allow surrogates to handle Article 81 cases in surrogates court so that expense would not be the same. But that's not going to happen either, because there's a whole other set of people who are unhappy with that idea as well. So I think what's really important is the alternatives to guardianship that Kim is going to talk about, because there may be the need for some individuals to have that type of plenary guardianship, but there's really, as far as I can tell, and I could be stood corrected, that guardianship is, as I think people have said already, is the priority. It's given priority in the proposals that are made to parents, by physicians, by social workers, etc. For many people, it's not understood until it's already been applied, and then they're realizing the burdens that are being placed on the now adult child who is under the guardianship. The choice between Article 81, leaving aside the expense, is fairly clear because the protections for the individual are more evident under 81, but the cost, as Carrie pointed out, it's unsustainable for most people. So that makes it a very difficult choice. The other thing is, and this is an education piece, nothing in the guardianship statute under 17A suggests that alternatives to guardianship exist, primarily because when it was written, they didn't exist. And nothing, the amendments to 17A have never reflected that. But if you go to the Surrogates website where you can find the forms for 17A, there's no mention there that would, before you consider this, maybe you ought to look at these other alternatives such as healthcare proxies, et cetera. The Office of Court Administration has its own guardianship section. And if you go there, all it talks about is Article 81. It's as if 17A people are invisible. And so I think that really, that educational component is probably the most important, because as you can see, as far as reform of 17A goes, it's a long slog. It's been going on for 30 some odd years, and I doubt it will happen anytime soon. So the road to inclusion, I think, is really the other alternatives that everyone can enjoy, which brings us back to the idea that legal capacity is something everyone should have the right to exercise.
So if I can jump in with a couple of questions, because I also see a similarity between what was presented to families around the Willowbrook era and what is being presented now to both people with disabilities and families. Many people, I think, Beth, you can probably attest to this, felt obliged to place their family members in an institutional model that, even if they knew that institutional model wasn't working, because that was the forced choice that was offered. And I wonder today that the conflict between reform in this area of decision making appears to place people with disabilities and their rights, in conflict with the pressures that family members are under, including the financial pressure that is placed under them. As again, I see it as this forced choice, like we have to choose between permitting people with disabilities to have access to their civil rights, or we have to choose between offering families a less costly endeavor. And it reminds me of those forced choices on families and individuals when forced institutionalization was happening. So I thought maybe I'd turn to Beth first for your comment, and then Rosemary too, about why why we're in that situation where it feels like a forced choice. And I do, Rosemary, want to get to alternatives, but I do want to examine whether this is a systems problem, not just a rights problem.
Yeah,
Beth,
I mean,
I'll go to you.
sure. And, again, the irony, right, is just so manifest. With Willowbrook, families were forced to actually transfer guardianship for all intents and purposes. They had to abandon their child. They had to terminate their parental relationship in order to have their child placed as a ward of the state. So you ultimately end up with the folks at Willowbrook, without parents, in the care and custody of the state, where they argued, parents patriae, we know what we're doing. We're doing everything for the best for your family member. Just make it easy on yourself, on your family. I cannot tell you how many records for class members, where parent was advised child died in birth, parent, told the rest of the family their sibling died. Don't contact the family unless and until the person in Willowbrook dies, just because they were preserving this sort of pretext that you now suddenly had a whole class of orphans basically living at Willowbrook under the custody of the state. So you fast forward to deinstitutionalization. We ended up in the Willowbrook case with the Consumer Advisory Board, which is a court-created entity to act in loco parentis, because so many parental rights had been terminated. So many class members do not have family. So CAB came in as the role of the parent. But what you saw with deinstitutionalization was, okay, you parents want to stay connected to your child's life. You need to exercise on steroids your parental rights and put them under an order of guardianship, keep them infantilized in order to be recognized by society as the legal spokesperson. It still depersoned the person. You know, there's no sort of recognition with deinstitutionalization that you were looking at allowing people to live, flourish, participate in community. You just transferred the sort of decision-making away from the state back now to the family. And, you know, again, you don't see the state. I mean, if you're in the Willowbrook, or if you're in the OPWDD system, there are alternatives, right? You have the ability for people who are deemed to be capacitated to have a healthcare proxy. You have the ability to act under OPWDD's regulations, but try going into DOH facilities with your list of OPWDD regulations. They don't know what that is. The Consumer Advisory Board carries about a 12-page letter that lists all of the statutory areas in which they are granted the ability to act. So if they show up in a bank, if they show up in a hospital, we have the legal framework, but no one should have to do that. And we haven't gotten to that point where the state actually gives full meaning to inclusion, right, and individualization, to say to the banks, you have to engage in a relationship with people regardless of level of disability. You can ask, I mean, you know, landlords always ask for guarantees from families when their children, adult children, are, you know, moving into the world, graduating from school or what have you. There are a lot of alternative opportunities that OPW has created within the OPW system. It just hasn't spread into, you know, this sort of general day-to-day community. So you still have the state permitting stigmatization and, you know, disregard of people with developmental disabilities. So I do think it's a systemic thing. And I think the state, you know, took the baton during the institutionalization era, passed the baton to the families to have to go to court, and just refuses, you know, they're like, oh, you're a family. This is individual choice. You can do what you want, but families are left without a choice, and people are certainly never afforded a choice if everyone is forced into this depersoning guardianship protocol.
Thank you, Beth. Rosemary, is there something that you would like to add?
Well, I think I would agree with Beth that it is systemic, that for all of the work on reform of 17A, leaving aside the issues of it being an uphill battle, it's like boxing in a small room. It's not really taking into account the larger picture. And I think that I'm open to hearing about how that's going to happen, because it is, the lines are drawn in a way that are very hard to overcome, even though they must be overcome. But I think it involves changing mindsets, not just educating parents. In fact, it's the other people that need to be educated rather than the parents, because they already know. And that's really the difficulty here, because I don't think other people are willing to listen.
Well, not to leave and turn to Robert Terry on a dark note, I did want to, though, introduce you to the discussion. And Robert has lived experience with guardianship. And I thought we could start. Would you like to just introduce yourself briefly, and then I'm happy to kind of ask you questions?
Okay, sorry about that. We're back on. So yeah, as far as my experience with guardianship, My experience with my guardianship was, what I know about it, the way mine was set up was I had three people that were my guardians. My sister, actually a lot of people. My mom, my Aunt Kathy, my sister, and my brother. So in order to do what I do, in order to remove the guardianship, one of the things that I needed to do was get all of them on board to remove the guardianship, for them to say okay. So that was one of the first steps.
So start me off with how did the guardianship impact how you felt about yourself? Because we've been talking really here about about the process, but was it hard for you? Like, were you aware that certain people in your life had to make choices for you, and how did that impact you?
I wasn't aware as much as I am now. Because all my family was told, and this is what I was told, or what they understood, was because when I was little, they basically told what everybody was told. He's gonna need help all his life. He's gonna need help with a lot of stuff. So he's gonna need guardianship. There's no other, there was no other alternative at the time.
So it's just presented as this is what needs to happen next.
Yeah.
When
So,
did you become aware of it? Like in that process?
for me, not till I was basically the age I am now, and maybe in my mid-20s when I started being a self-advocate and all the other stuff. And then I realized myself, wait a second, in order to do what I need to do, I don't need my family's help to do all this. And that's when I started pushing for not having a guardian.
So did you have to have those discussions? Like, did you have to go to your guardian and say what? How did the conversation happen?
Well, with my parents, that was with my family, basically my mom. And it took a lot because she was coming from the old way of thinking, and I was coming from the new way of thinking, to put it bluntly. So we had a lot of hard time communicating, and that affected our relationship on like being able to talk to each other about it. So I needed to get people that supported me, that was already supporting me, to vouch for me and help her understand I can do this. Because they would always tell me, oh, I'm very independent. In fact, when I was living in group homes and stuff, they were like, you're not going to be here long, because the goal for me was always to get my own place, to have my independence. But it just, because of legal things, it just took a long time.
When you said old school of thinking versus new school of thinking, what do you mean by that?
Basically from, like I said in the beginning, my parents were told like, oh, he's gonna need this, he's gonna need that. Because they didn't think I would be able to talk. They didn't think I would be able to take care of myself. They didn't even think I'd be able to make all my own decisions. And obviously I've proved them wrong over the time. So just because of legal things, and we were told, oh, it's gonna take a heaven and earth to remove the guardianship. It's gonna take going to court. It's gonna, do all this. And for us personally, between me and my mom, it was a thing where she was basically thinking, oh, I have the people that were supporting me in on my corner about this, or were filling my head, you know, saying all this stuff, you know, and basically
You
she
didn't
was,
trust the people that were in your
yeah,
life that you were trusting.
she didn't trust the people I was trusting, basically. And until one day, the light just opened up and she really, long story short, she realized it was her fuse stopping her from realizing that I can do all this. So,
So
and
yeah, that fear gets in the way of, that fear, the want to protect you.
yeah, for her it did. And one of the concerns she had was, oh, he's gonna lose all, he's gonna lose all his money. The state's gonna do all this to him if we take all this away, if we do this, because that's what she was thinking, that's what she understood. So, and once she realized, oh, it's not gonna happen that way, she was all on board for it, long story short.
So, but I'm very interested in the story of that kind of transition of how you think you got there. So I understand that you were having conversations about you within your community. Is guardianship something that you talk about with your peers? And what are the conversations like with your peers around guardianship?
Well, when I talk about it, I basically talk about it from where I'm coming from, my guardianship, because I know everybody else's guardianship is totally different. So maybe different. So I don't want to, you know, I tell them, but I also tell them have high expectations to, but kind of what to expect, because I don't. Everybody's situation is different, so I don't. It depends on. From my view, it depends on everybody's situation.
Is it that expectation for yourself that drove you to have, I mean, this seems like a really difficult conversation. I think all of us can appreciate going to our parents and saying something to our parents that we don't think our parents want to hear, and the crushing way they can, impact us when we feel like we haven't made them proud. But is that setting of the expectation for yourself what drove you to that conversation?
Yeah, and it took for me, it took a whole lot of people backing me, because for a long time I didn't up until I had so many people backing me and saying, no, go ahead, and being able to help me with the conversation with my mom, because I said that whole communication, we couldn't talk one-on-one. Because she had the power, even though I wanted to say something, I felt like I didn't have the power for the longest time, because she could just automatically say, no, he's not doing this. I don't care what he says. I don't care what you say. So.
One of the things that we hear from people who talk about their own guardianship and talk about the process of getting their rights back is that you're just unique, right? That there are so many other people that that are under guardianship and need them, and there's so few that are under guardianship that don't need them. And I wonder whether you can comment on that when you're talking to your peers. Do you feel like you're in a unique situation, or do you think other people are kind of struggling with the same thing that you had to struggle with to get to your rights?
Well, the only way I felt unique, because I up until I started the program I'm in now, I didn't really think about it until it wasn't really something that bothered me up until I realized myself, like, wait a second, in order to do all this stuff, until I learned about the what the program I'm in now, you know, and learned all about it. And I learned more and more about it, and my family learned more about it, that we were all on board doing it. Now, to get the guardianship removed, that was a whole other, it took a long time too.
So you're talking about supported decision making and your process of going through that that kind of program. So talk to me a little bit about how that helped you get to a place where you were looking to have a guardianship removed.
Get to a point where I felt comfortable, um, talking to everybody about it. Because once I know I really could do this, then I was like, okay, and had the people backing me. Okay, I'm gonna push this. I said to myself, okay, I know I'm gonna get pushback from certain people, but I'm gonna keep pushing this, and I don't care what they say. I was ready to go the legal routes if I had to get, to get to where I wanted to be. So
Well, we appreciate you sharing kind of that story, and I know that there's several questions in the chat that we'll get back to. I want to return to you during our question and answer session, Robert. But I do want to turn to Kim Weisbach just briefly, so we can finish off what I think we're getting into next, which is these alternatives to guardianship. It's talked about a lot as this alternatives, but what are the true alternatives that exist today? And why are they really alternatives, and do they result in in replacing the need for guardianship, or are they a tool as a component to guardianship?
Yes, and I'm sorry, I wasn't on the original panel list. So my name is Kim Weisbach, and I'm a supervising attorney in the PAD program here at Disability Rights New York. I am going to take a few minutes to talk about some alternatives to guardianship, to 17A guardianship. There actually are a lot, and I want to be mindful of the time and to allow plenty of time for conversation after. So I apologize if I go through these quickly. I want to start with the first, what I think is the obvious alternative to 17A guardianship, which is Article 81 guardianship. Rosemary spent a lot of time talking about it, so I'm not going to focus too much about it, except to say that one of the differences is certainly that it provides the due process rights to people facing guardianship that they're lacking in 17A. Also, Article 81 provides a thorough review of a person's functional abilities and deficits. And I saw that there was a question in the chat, and I know we're going to wait until the end really to have a good conversation. But I think that this does address the question of, doesn't any guardianship come down to the severity of the disability? Article 17A guardianship doesn't consider the severity of the disability. To get an Article 17A guardianship, two doctors need to check some boxes on an affidavit that basically says a person has an intellectual or a developmental disability that's expected to continue for the duration of their life. But there's no requirement in Article 17A that the doctors checking the boxes actually conduct an assessment or evaluation of the individual. There's no requirement that any evaluation that was conducted ever be seen by the judge granting the guardianship. So it really doesn't come down to the severity of the disability. In 17A, that's not really considered. It's just, do you have a disability or not? So Article 81 is certainly different in that regard. Another part of Article 81 is the existence of the single transaction opportunity in Article 81. Section 8123 of the Mental Hygiene Law allows for a temporary guardianship. So when a person is in imminent danger, or a judge can appoint a temporary guardian to address the immediate concern that exists for that individual. Article 81 also allows for the existence of what's called a special guardian, and that's to achieve a service or to oversee a contract or a trust or some other transaction that relates to the financial affairs of an incapacitated person. So this kind of flexibility exists in Article 81 that I think a lot of people don't know about. So if a loved one has an immediate concern for their family member, there are these different options. Certainly supported decision making, which I know Robert went through, it is a real alternative to a 17A guardianship. It allows for individuals with a disability to participate as the actual decision makers. Decision makers retain important autonomy, and they choose what decisions they want help with and who they want to help make those decisions. And those people are called supporters. The decision maker and their supporters work together with a facilitator, and they develop a supported decision-making agreement. The agreement then outlines who provides help with what types of decisions and how those decisions will be made. The participation in this kind of participation in supported decision-making is purely voluntary, and there is no court involvement. So those are the basic, the biggies. But I want to focus on the two main areas that I hear in my practice at DRNY where that guardians or loved ones are really concerned with, and that they think that an Article 17A guardianship is the answer to help address their concerns. And the first is property issues and a fear that, and someone did talk about it, might have been Beth, that their loved ones they're going to lose their money. The state is going to take their money back. Maybe it was you, Carrie. I can't recall, but that there's a fear of protecting assets. So one alternative to a guardianship would be a power of attorney. Power of attorney is a legal document where a person designates an agent to make certain decisions on their behalf. That can cover banking, that can cover property management, that can cover payment of taxes. The power of attorney can be tailored, so it can be very broad or it can be very narrow. The powers of the agent, who's the person who has the power, can be limited, and it can be they can be made effective immediately in a durable power of attorney, or they can be made contingent upon the happening of some future event, which would be called a springing durable power of attorney. Another option to help protect the assets of an individual with a disability could be an ABLE account. An ABLE account can be set up, and these are accounts that are, the earnings are tax deferred, and it's tax-free. The money is tax-free, can be taken out by the individual with a disability so long as it's used for a qualifying disability expense. And that really means that it's related to a person's disability, and that the expense is, the money is being used for the benefit of maintaining or improving the person's health, independence, or quality of life. That money taken out of an ABLE account can be spent either by a debit card or by check. The account owner, which is the individual with a disability, can authorize another person to be able to make deposits and make withdrawals. And that can be done through a power of attorney form. It's quite simple. Automatic withdrawals could be set up through an ABLE account to pay recurring bills. And there are different investment options that can be chosen by the individual and their supporters, which range from aggressive to conservative funds to help manage the account. Balances under $100,000 in an ABLE account is that money is excluded from SSI resource limit. So it allows a person to continue to be eligible for SSI so long as the amount in the account is less than $100,000, and it does not affect Medicaid eligibility. Another option for protecting assets for a person with an intellectual or developmental disability is a supplemental needs trust. And I'm not going to spend a lot of time on this, but the general purpose of supplemental needs trusts and also pooled trusts, and I'm going to kind of lump them together for purposes of time, is to enable people with disabilities to preserve their eligibility for government benefits, mainly Medicaid and SSI, while also providing access to trust assets that enhance their overall quality of life. Another way of protecting an individual's financial situation is to use a rep payee. A representative payee is a person or an organization appointed by the Social Security Administration, and their job is to help an individual maintain and manage their Social Security benefits. A rep payee has the responsibility to help an individual pay for their current and their future needs: food, clothing, shelter, dental and medical care. And the payee can also help the individual with saving the additional money that's left over at the end of the month. Anyone can apply to be a rep payee, including a family member. An individual can work with their family member to go to SSA to set up the rep payee system. So there's really a lot of options for families who are concerned about managing and protecting an individual's financial assets. The other big issue that we hear about that people have legitimate concerns about is helping a person with an intellectual or developmental disability make decisions about healthcare issues. So there are also several different options for that, and one basic alternative to guardianship, or part of an alternative to guardianship, is a HIPAA release. Having an individual sign a HIPAA release to allow their family members or the person that they choose to have access to healthcare providers and medical records to assist. Another is a healthcare proxy. Healthcare proxy is a legal document. An individual can appoint an agent to make healthcare decisions for themselves in the event that they become unable to make their own decisions. Very briefly, there is the Surrogate Decision-Making Committee, and if an individual who has a disability is faced with a situation where they're in need of medical care, it's an alternative to the court system. And there's a committee that's authorized to provide consent for non-emergency major medical decisions and also end-of-life care decisions for individuals with IDD. That really exists for either current or former OPWDD recipients. It's often used for individuals who reside in group homes who don't have guardians, and they don't have, or any other authorized surrogate. And what the Surrogate Decision-Making Committee is a volunteer panel. They make decisions for free and quicker than getting involved in the court system. Beth, I think, mentioned the Healthcare Decisions Act of 2008. There are avenues for family members and individuals to go down to make a plan for how to deal with medical and healthcare decisions. 1750B and the Family Healthcare Decisions Act and the MOLST system, the Medical Orders for Life-Sustaining Treatment, both exist. The MOLST are medical orders that are signed by doctors, and they follow requirements in the Surrogates Court Procedure Act, to assist with end-of-life decision-making for an individual. It requires a finding of incapacity made by to make healthcare decisions by an attending physician, and a concurring opinion by a doctor or a psychologist who's familiar with the individual. It can be completed for people who don't have a guardian or a healthcare proxy. And it basically complements, well, we can get into that later, sorry. So there's also rights of actively involved family members of people who live in OPWDD operated or certified residence. And it's covered by the mental hygiene law, section 33, and it the regulations are have been created. It's Regulation 633.11 dealing with medical treatment. And anytime professional medical treatment is proposed where informed consent is required, OPWDD or the provider agency must ensure that the individual is given an appropriate explanation of the plan for treatment and obtain consent from that individual or their surrogate, except in cases of medical emergency treatment. If an individual is found to be lacking in capacity, the informed consent must then be obtained by either a guardian or a spouse, parent, actively involved adult child, adult sibling, or any adult family member, or the surrogate decision-making committee. So there are safeguards in place to ensure that individuals with developmental and intellectual disability are aware of their options and also protected in ways that really cover what we see as a lot of the concerns that guardians appropriately have on behalf of their loved ones.
So I want to take some time to jump into some of the questions, and please feel free to put them in the chat. But Carrie, I was actually going to turn back to you with the first question and to reflect on some of what Kim has just presented. So what Kim's presentation is about kind of these alternatives. With the presentation we heard kind of today was about the existing system, but you started us off with this conversation about not feeling like the alternatives work and not feeling like the current system work. And I wonder whether you could get into where that gap is or where that gap was for you. And one of the questions that was presented is that many IDD families lack, like they live below the poverty line, they can't afford, a big expense. And so thinking of that as the framework of where you came from, where are the gaps? If one did not want to turn to guardianship, what are the things that are still missing to make one still turn towards a plenary guardianship, even that if that's not in their desire to do?
Oh, okay. So to go back to the beginning question, I think, so I don't know a lot about supported decision-making. And I think the reason why I don't is because there's not a lot of readily available information for families. And so I look at it this way: if I work in this field and I'm confused, then I know that there's not a lot of good PR work for supported decision-making. So supported decision-making may be a partial answer. I think though that when you look in our house, and Ella specifically, her receptive language is much, much better than her expressive. And so when I picture just a supported decision-making meeting and all of the people around asking all the questions, my assumption is that verbal answers are needed and a definite assurance that she is fully understanding how the question is posed. And I don't know what that is, and I don't know how much plain language is used. And so I think that, so I always think of solving these problems, these big problems, and like my big wish list, right? Because then that allows me to not work in the rules. I hate the rules. And so if we put the rules aside, what I would love to do is to form a group of all kinds of people that are very invested in this. So stakeholders from everywhere. So attorneys that absolutely know what they're talking about, like the people that you see before us, and self-advocates that are directly affected by this, and they should be the center of it. And then the families that are also directly affected by this and what we want to come together to form this solution that really does work for everybody and is person-centered. Because if you think about it, all that we've been talking about, there's not a lot of person-centered to this at all. And I think that that's really one of our problems. I also think the financial piece of it, like, yes, I don't have a stack of cash next to me. I do, though, know that there is funding. Self-direction is able to fund things. They do help with with 17A, they probably could help with something like 81 too. But again, that would take all of us coming to the table and figuring out and having these conversations. I think with guardianship, there just haven't been enough of the conversations with the combination of right people to be able to really work on this. And I think that that's what's lacking. And I would love to see something like that built moving forward. I think what happens is it's a fear-based decision, right? We're making it based on fear because, and you know, what Beth said really rang true is the what ifs. So what if Ella is hospitalized and I can't help advocate for her? And, you know, I just said her expressive language, especially when she's stressed, doesn't always come through, then what? That alone right there, I think, is why a lot of families just say, okay, 17A, that's it. We can't, you know, we can't handle, with all of the other domains we're trying to figure out, housing and schooling and employment, like it's just one more thing. We're just going to do this and let's just go. So I think that's a long answer to your question, but I think that creating groups coming to the table and figuring this out, I think is how we are going to sort of tackle. I think it's the best way to tackle this issue. And I see it being done in many other issues in our community. And I think that this is just one that needs to be put in the center.
Yeah, I mean, certainly coming from a fear-based approach to try to resolve a systemic problem is often, you don't ever get to the solution you're looking to hope to do in terms of reform. I do think one of the questions that did come up, and I can offer it up to Kim as well, is, can't I just do, and maybe Carrie, you kind of led to this as well, can I just do the 17A now, and then I'll when something else comes along that's better, I'll move to that better thing later? And what are the consequences? Kind of, we really didn't get into, and Robert, you experienced this, the challenge of restoration is that under a 17A guardian, we have been talking about how easy that process is, and how quick sometimes that can be depending on what surrogate you're in front of. But we haven't talked about what happens to the kind of the family dynamic when you try to remove it later, even if everyone is in agreement. And Kim, maybe you can jump into that. And then Robert, I'm going to go back to you with your experience as well.
Yeah, just real quickly about the process of removing a guardianship in surrogates court. And I'm going to go back to what Rosemary said about when you go to the Unified Court System website, there's a whole guide to obtaining guardianship. They lead you through the process step by step and take the petitioner through, and it's very simple to obtain a guardianship in New York State Surrogates Court. There is no such guide on the website for removing a guardianship. There's no one driving the boat there from the court system on how to actually remove guardianship. So it's a process because there's no uniform process laid out in the statute. Every single county, every single surrogate court judge has a different idea of how it looks when you're trying to modify or remove a guardianship. We've had plenty of occasions where we've contacted a surrogates court and the court clerk has told us, well, you can't remove a guardianship, that you can't terminate a 17A guardianship. Well, indeed you can. It's just that it's never been done in every single county in the state. So it's not that easy of a process. And as Robert experienced, it takes time because judges want, while it's very easy and there's no need for a judge to see any evaluation to prove that a person needs a guardianship, they're very hesitant to remove a guardianship that's been in place. So there's really a double standard there, and it takes a lot of time, and it depends on the court as to how much convincing it really takes, which leads to a whole other issue that we don't need to get into right now, I suppose, in 6 minutes that we have left, which is who really bears the burden of proving that a person either needs a 17A guardianship or certainly doesn't need a 17A guardianship. So it's not as simple as one might expect.
Robert, was that your, I mean, you talked about the experience, you were there for the experience of the application of the guardianship, when you got guardianship over you, and then through the process of removal. Is that your experience in terms of it being more challenging to get the guardianship removed than it was to get
Yeah.
placed under guardianship?
Like she was saying, because like I was saying earlier, it was just automatically, it was something like we had to do. It wasn't, it wasn't explained to us. It wasn't, it was just something like we were told. Because when I turned 18, I guess, from my understanding, when I turned 18, I was automatically put in the guardianship because of my disability. It wasn't an option. So to remove it, it took a whole bunch of people saying, yes, he can do this, yes. And it took the person who was helping me, my lawyer, to prove and to talk to not only me, to get a lot of proof, and to get, from my family, and to get everybody on board to say, yes, okay, yes, we agree to remove the guardianship.
Yeah, I think your experience is similar to ones that we've had in terms of it often takes more to prove that you're capable than it does to prove that you're not capable. I mean, with some of the questions that did come up, and I'm going to summarize some of these for the panel, is, is the problem that with the application of guardianship 17A in particular, that they're just that it was just a mistake, let's say in your case, Robert, to place you under guardianship because clearly you don't need a guardian? Or is it is there something faulty with the system, or is there something faulty with the statute? I think that is a summary of a lot of questions that are being sort of sent up, with this idea that maybe those that are listening have family members that don't think that they could perform the way that Robert did today, and as articulated as he is. And Carrie, to your question of, can my family member really participate in this because their expressive language isn't as good as their, isn't as strong as maybe what you're seeing in this presentation. So I don't know, Beth, I don't know whether you want to jump in. Go ahead.
Sure. I mean, from, where I sit with my civil liberties hat on, any guardianship should be, a step of last resort. There should always be an assessment of what is it that you need to accomplish as the person and or the family and supporters. What do you need to accomplish and how do you get there? And I think if you're in the OPW system, okay, fine. I've certainly told like CAB, they can proceed under the Family Health Care Act as an involved next friend or family member. For transactional purposes, one-shot deals where there's not really a lingering capacity decision that follows the person around is a good way to go. But, I would try to stay as far away from that as possible. I mean, we didn't even talk about, capacity of an adult to engage in childbearing and relationships. When a person's been depersoned and had their capacity taken away from them, that's it. It's a crime if that person engages in any sexual activity. And there are really enormous repercussions to the way society responds to perceiving the person to have been the victim of a crime because they don't have capacity to consent. So, you could do a whole seminar on that, but I do think you need to stay away from guardianship as far as you can be, last resort. And, the system has just not caught up to contemporary, considerations.
Right.
It just has not. And you've got, a legislature that's terrified that something bad will happen, or the lobbyists from the banking industry and real estate and, you name it, commercial industry and the hospital associations are also on them because nobody believes a person has capacity. They think that they're completely incapacitated. For people, I mean, when we have 17A orders issued for class members, because we really, don't have the wherewithal under state law or under the injunction, we try to make sure that that order is as tailored as possible so that there's no overstepping. So, but it's always with an eye towards, understanding what the person is articulating and meeting them where they are, because every person, whether they're verbal or not, has the ability to communicate likes, dislikes, maybe not at, a high functioning level, for want of a better word. But, the fact is, when you take time, when you're person-centered, you can actually understand and effectuate, and not in a paternalistic fashion, not in a substituted decision-making standard.
Well, we've come to the 4:30 hour. I do hope that each of you leave here with a recognition that this wasn't a panel trying to demonize guardianship, that there is that this is a panel that's passionate about this topic, and that passionate about making this system work for all those that are within it. I want to thank each of you for taking the time to talk about this topic with us and giving us the opportunity to ask our questions of you. I hope that each of you stay engaged with these sessions. As I said at the beginning, DRNY will be hosting events throughout this year on a variety of topics as we reach the anniversary of Willowbrook. And I look forward to you participating in the lively discussion on those topics in the coming months. Thank you all for attending.